I've been taking my time, taking all of your time, taking all of your time.
Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Let me know if you can hear me. Happy Friday. Let me see. I'm waiting. Just make sure. I see I'm vibrating. That's a good sign. There we go. Miami J. Okay. We're going to start with greetings. I have a couple announcements, and then we're going to get into this YSL trial. Okay? All right. Let me see. Hi. How are y'all? Hey, Gloria Williams, first in the building. Hey, my big sis, Peaches and Cream, Sweet Rose, Bonnie Mason, Helen Lane, my legal eagle, Shan. Hey, Shan, how you doing? Part of the Mod Squad. And Peaches and Cream is part of the Mod Squad. Hey, Sweet Jane, Rhonda F, Katz, Kim Jones, my sweet sis 41 Fit is here. Hey, 41 Fit, she is a content creator and part of the Mod Squad. Hey, Michelle Tuff from Seattle, Linnell Seiler, Professor Purple Queen, April with the 2 L's. Okay, so I want to just say hi. I'm doing fine. I'm glad to hear it. Hey, Ruthie Lewis. Hey, Divine Virtuous Woman. Hey, you made it on time. Hey, Miami J. Hey, VG. Okay. Oh, I see Demi. Hey, Demi. And Cha Cha. Okay. Oh, I'm gonna stop here. Tanika Lachey. Okay, I'll stop there. Hey, y'all. Yes, this is the infamous unit that I had a rant about. This is the one. I am I'm recovering from that rant. I still mean every word I said, but I'm recovering from just getting over it and moving on. But this is the infamous unit. It is. Okay, so let me see. Oh, announcements. What's on the docket? So first of all, Saturday Night Giggles is again this Saturday, normal Saturday night time. I was supposed to download the image. Don, don't kill me if you hear this. Do not kill me. But we have a special guest. So barring any unforeseen circumstances, we have Saturday Night Giggles this Saturday night. And I'm excited. Then also today, hopefully Jay Taylor and I will be on Instagram live because he's going to do an unboxing of some of his new one of his new trendy merch items. So please, if you're not following me on Instagram or following Jay Taylor on Instagram, please check us out because we should be live tonight, this evening, tonight-ish. So check 7 or 8 p.m. Eastern Standard Time. But if you keep your notifications on, you should see it. So I'm excited about that. And I heard he was over there trying to talk about me because I had got him a gift. Then he gonna dog the gift out because he didn't know how to end his live. That was not on me. My gift was not janky. But yeah, so I'm excited about it. And Sunday night, we got a packed weekend. Sunday night, my sweet sis 41 Fit and I review House of the Dragons episode 3. So I'm excited about that as well. So we have little treats coming for y'all, but we just are enjoying watching the show. I didn't get to watch episode 3 yet, so don't say nothing yet. Okay, it's spoiler alerts when we get over to our show. It is Two Queens and a Throne. Okay, that's the name of our show, Two Queens and a Throne. But yeah, I really enjoy doing House of the Dragon review with 41 Fit. Again, if you were here in the early days, she was one of the ones that said, I love House of the Dragon. Can't wait till it comes back. And then to be able to do a review with her, I am so excited. So we have done episode 1 and 2 in one take. So you can go to 41 Fit's channel and you literally just got to search 41 Fit. But Nightbot hopefully should be dropping her link. 41 Fit is in here, so she can drop her link in real time. But it's on both of our channels, so please check out episode 1 and 2 review. Shout out to the book readers of House of the Dragon as well. We try to honor y'all in there in the review too. Yes, y'all better come out and watch. Like she said, we ain't too proud to bed because the algorithm is not gonna notify you. It's not gonna notify you about us in House of the Dragon. So we gotta let y'all know, word of mouth, okay? So yes, it's nice. I'm excited. There we go. There goes Shan. One of the Tauruses. 41 Fit and Shan are Tauruses. But yes, okay. So let me get my screen set up here so we can look into this YSL trial. It's not an update for y'all. That's why I said it's more of a reaction, because most people that's following it, you already know. So this is more of my reaction to some things with it, and if I have any thoughts about it. That's what we're doing because y'all already know that's been following it. Shout out to Bam Bam. Let me see here. Okay. Share screen. So first we got to see when the attorney was basically held in contempt of court and arrested. We got to start there because the judge was on his high horse on that one. Okay. He was on his high horse for that part. And then we're going to get to him reading out the order or whatever he read as far as his possible recusal and everything. So that's how we're going to lead up to that. But y'all got to see or watch it with me if you've already seen it, how he acted when he was just like, I'm just trying to figure out who told you. And they're like, you shouldn't have had it in like that anyway. And I have to give it to Young Thug's attorney, the team too, because not just when that attorney got held in contempt, the next one came up and said, we just wanted on record that this is not this is not following protocol. Next one, I think he had 3 total. The next one, I just also want to state this is not following protocol. So yeah, shout out to his attorney because man, that's who I want. Stand 10 toes down for me. Okay, stand 10 toes down. American Born says she's ready for that House of the Dragon review. 41 Sis said, baby, we begging. Yes. Okay, let me see here. All right, so there will be a little bit of a pause between when I come back on with my audio because I'll be changing up my audio input to make sure y'all get the best sound quality for when the video is playing. So if you're like, why is it taking a little bit longer? I'm changing my audio output and input. All right. Get that up there. All right. And again, this is my own reaction. This is a remix of original content. I just want to, give my thoughts to something that has happened. Okay.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again. And I respect that. And
gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6 comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
But in order,
Interrupt.
you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah.
Okay, so the judge is standing on who told you, because you weren't supposed to know in the manner you found out. And he doesn't want to hear anything else about how it shouldn't have happened the way it happened. And so he's like, I want a name. Shan said if being caught was a person equals Ural Glanville, and that's the judge's name, Ural Glanville. Yes, because now obviously he would care if he had a leak. He would care. But the bigger issue is you didn't follow. Apparently, he did not follow ex parte rules, because ex parte means the other party doesn't have to be present or is not present. But the way it went down, which we're going to look at, shout out to Shan for suggesting this channel. We're going to look at the Lawyer You Know's channel when they break down when the judge then comes and changes his tune some. Because they were saying how, like, the people that were in there, this is about Lil Woody, by the way. The secret meeting was with Lil Woody, so you'll hear them give him his actual name. I think Copeland is his last name. But all this is about Lil Woody, because Lil Woody was going to be a witness for the state, which then, of course, would not help the defense. And it seems like he was pressured into giving testimony, and, he was given immunity, but he was pressured into even doing any of it. Especially once they listed who was present in the courtroom when Lil Woody was, sat there and then, had the ex parte thing with everybody. So it's just interesting his and a couple of the prosecutors' attitudes, and I don't mean nasty attitudes. I just mean like how they're receiving this pushback. How they're doing this, and it's very much giving high horrors, but it's like, if you want this case to go well and not, be a mistrial or anything else, you got to keep everything above board. And I don't think he would have let the attorneys speak if the attorneys had went ahead and said who told them, versus them trying to go ahead and give why they are opposed to what happened. Yes, Demi, Lil Woody, he was the one that was in there for that ex parte. So okay, so I'll let y'all keep going, but hopefully that helps a little bit, just in case there wasn't enough context.
Yeah, that's why I raised it. Is that serious that we should have been there and it shouldn't have to?
That's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
Ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me maybe you're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not sub and substance, but I'm telling you, I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not
sure. I don't want to hold you in contempt, but this is that serious,
Judge.
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have a.
When I got this information,
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this. So
that's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele. That is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying, if you read I'm assuming you read it. That's what it says. And you.
Sorry, I'm switching into my settings. Yeah, okay, so that sounds straightforward, that he's not supposed to have communication with a witness that's been sworn in. So that's that's very straightforward. And he's gonna keep citing. He's like, I'm just citing, what applies here, and the judge is not having it. Again, I say whoever, I don't know if that dude was second chair after him, third chair after him, but again, I applaud them for standing 10 toes on what they know. This is not right. He's not even under his own criminal docket, and that is in part the fault of the judge not properly handling things. Ooh, wow. Okay, we'll keep going.
Did it? The state was speaker. You said
Supposedly.
Yes, John.
And what I'm trying to get to is
State
why
does.
did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we
that leads to be told. But
right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right under
Just
the
stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you've already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Lowe.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh.
Ms. Lowe.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed.
Okay, real fast, pausing it here. They doing everything but addressing the issue of how they had this ex parte. they doing everything else. Like we've had she's saying we had other questionable things happen. They're not the defense attorney. He's not answering our question, and it's like, but should you have had the ex parte though? So it's and it does give that Glanville and the state had some sidebars to get an understanding of how things were gonna go, and they're a united front right now, so yeah, interesting. Oh, Valencia said, wasn't she the one signaling with the judge? Now, Valencia, let me know, because I know for y'all y'all are more in tune with everything. You probably give me more details. But I know somebody in this chat is going to answer the question, but I'd like to know as well. But it definitely is giving me, without background, these conversations don't seem right. They don't seem right. And it's giving, I already know Judge Glanville's on our side. So I'm just saying a couple things, but really, like, defense can go have a seat and we will proceed how we want to proceed. That's what it's giving me.
The way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as it's standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained.
Okay.
Okay. And again, because this is, it's not my content. If anyone's, newer to it, that's why we offer our commentary. We have to break this up. It can't just be played straight through. So I apologize. Well, I don't apologize. I will leave the links in the description box if you want to hear without interruption and straight through. So now is this the second chair, Shan? This is where the other attorney comes up and is about to say what he needs to say. And as Shan did make a good point, they're getting it on the record, and the state is like, they don't need to say it again unless they're going to answer our question. But y'all are the fruit of a poison tree, though. Like, I am. Defense attorneys like this is what is needed. You need someone to have that strong backbone and keep going. Yeah, but it's obvious, but also interesting that she's like, before he speaks, if he's just about to say the same thing Mr. Steele said, unless he's about to, provide some information on, who told them or whatever, we already heard it from Mr. Steele. Plans and Pens, I like your names. Says, hey, new subscriber here. Miss Love is so annoying, and the judge allows her to run his court. That's what this is looking like, Plans and Pens. Okay, because that's the feeling I'm getting too. That's what I'm getting to. Okay, good to know. Oh, and let me tell y'all, I appreciate y'all so much for being here. Like 41 Fit said, y'all could be anywhere, but y'all are here. We are going to, Shan said, hey, Plans and Pens. We are going to follow more of the beginning to the end, which it might take us longer, which means that's why when the hotter hitting things come up, we got to go ahead and do those, because I don't know if I waited and just went in order right now, I don't know if we catch up, and y'all definitely would like to hear what's going on now as well. So please come back to when we kind of start more, because I want to see about that other attorney that got arrested because she was in some kind of GANG activity herself, and it was weird. I need to know these things so some of us can catch up together, and the ones that already know can go ahead and sprinkle in your backgrounds that y'all know about and everything. And I think that makes it really interesting. So I know I'm jumping in the middle, but as I was advised by my wise Shan, we gotta get back to the background too. So we will do that. I'm trying to make time, but yes, I'm interested in the whole case. I really am. Okay. So let me let her go ahead and keep talking.
The court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay. Yeah, he does. But
The court, now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay.
As Shan pointed out, they are emphasizing it was a sworn in witness. That is very important. And they just hopscotching all over this. When I say they, I mean the judge and the state hopscotching over the fact that it was a sworn in witness. Plans and Pens says Shan so true, and the judge cannot understand that. I truly think he doesn't understand the law, or they have gotten away with this for so long, it's normal to him and the state. Right. It could feel so normal that he just think he right, Plans and Pens. Right. That's very true. Because if you get used to getting away with it or doing something some way for so long, you might be like, no, I know I'm right, but you were always wrong, but you got away with it forever. That's true too. That's possible.
Same thing. You want the Harvey? Okay. All right. Okay. Mr.
I'm adopting all of the same.
All right.
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Mark Davis Huey.
Okay.
We are also adopting all the arguments that have been made.
All right, sir.
Still by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Giggles Weinstein, We also, Your Honor, we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an communication that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for a mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. T. Williams?
All
right, thank you, madam. Motion's denied. Mr. Gardner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. Once he clears the area, we'll go ahead and get started.
If by that point means we'll get started and resume the trial, Your Honor.
Yeah, we're gonna continue. I'm not caught nothing.
I'm not going to participate in.
You hear that? Did you hear that? We're not halting nothing. That was the attitude of that day. We're not halting nothing. That was his attitude then. And Shan said apparently he was a brigadier general of the U.S. Army Reserve Legal Command. Now I understand why he's like this. Shan, that makes so much sense. You cannot tell generals almost anything unless it's a higher ranking general telling them something. So yes, Shan, that makes sense. No was not in the vocabulary of him receiving it. He probably only said no to people, right? Oh, that makes so much sense. That makes so much sense. I did not know. Let's see here. And good afternoon, Leah's Grandma +1. Shan said at this point, has he approved or even considered any motions submitted by the defense in this trial? I didn't hear any approved. And he was quick. What? And that's the other thing. He was just like denied. He was quick. He was quick. Just like he was when Lil Woody was being questioned. And he was very quick to let the state do their questions in the manner they wanted to do until more the very end. He kind of started letting the defense kind of challenge stuff, but most of it he was like, let her finish, overruled. So yeah, it's giving more of that. Plans and pins that see how comfortable he is denying the mistrial and recusal request. That's not the law. He is on such a power trip and ego. Right. Oh, Bonnie, what did I say? Who was what? Oh, the judge. The judge was a brigadier general, Shan was saying. That was the judge. Hey, T-Rena. Okay. We're almost done here, and we're going to go into the lawyer you know. Thanks again to Shan for suggesting that channel, because I don't have a legal background, and this is a perfect mixture of we can both get some of our questions answered and then our interest in the law without our legal background. You know, we can get the experts in here. So I really love this. So shout out to Shan. So we're almost done with this one. We're going to go into the lawyer you know, reacting to this judge talking about recusal. So yeah.
You don't have that luxury. Time, sir, you don't have that luxury. You don't have that luxury at this point in time. You don't.
Addressing the issue we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Respectfully, I will not. I cannot. Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then you've made no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Okay, this is where I get excited, because now there's going to be two attorneys. I know one's an attorney. I'm still learning the background of the other one, but they're going to be giving their reaction as the judge goes through his recusal and everything. The judge's tone is different. So I wanted that to be fresh on y'all's mind while we look at the judge's tone in this one. So it's going to be interrupted by the reaction of the attorney, and then also my reaction to them reacting sometimes, because yeah. Okay, they answered Bonnie's question. Yeah, Mr. Steele is the defense, one of the first chair, primary chair defense attorney to Young Thug. Yeah. Yes. Dang, B. Wallace, you said the judge gonna go to jail. Go to jail. This is when the state starts to get real worried. They know they messed up at this point. Plans and Pens, Shan, Bam Bam, all my people in Valencia that have been watching this. Do y'all think that the state's attorney in the braids, do y'all think she was trying to look up the Georgia rules? Like how the defense attorney was citing the Georgia rule for ex parte, sworn in witness, and all this stuff. Do you think she was over there frantically searching for a Georgia rule that would support their case on record on why they did that action? Because she stayed on this, even though she kept typing and typing and typing, most of the time it looked like this like government like layout. I couldn't tell, but I was like, I wonder what she over there searching. Shan said I watched till like 8 that night and they never took Steele away. Oh, okay, got you, Shan. Okay. Okay, Plansmiths, I've been locked in since March. Okay. All right. You think she was looking to check for validation? Yes, yeah, I think as people stated in our last one that we did, I think one of the bigger issues is that they're going after the famous whale, which will be Young Thug, versus just honestly going after the person or group that kind of actually committed the crime of unaliving someone. And it's like, if you're this is the media circus, but now you're scrutinized for following these rules. The judge will for sure use some of them, right? Yeah, Shan. Okay, that's where I was going. They were trying to find something to help them and the judge be right. Okay. Let's get into the lawyer. I will have the links in the description box sometime tonight if I can't do it as soon as I get off the live. But here we go. Let me get my sound together. And we will enjoy this together. I only got to see up until about the 20-minute mark, so it'll be my initial reaction after that point to what they say. But they were making some great points in the beginning. I think we're going to enjoy this. I think sometimes people be trying to win their case so bad. And like they said, maybe they're so used to bending the rules, they weren't even looking at bending the rules. They thought they was really in the right because they really were taking the position of they were in the right. So that's the thing too. Okay. So let's get this up here. Let me see.
What are you gonna do then?
Ooh, hold on. I gotta get it to the screen I wanted it. Okay. So shout out to the lawyer
All right, Dad, the first thing we're going to watch is the short clip of Judge Glanville basically making it seem like he is agreeing to have another judge take a look and make a decision as to whether or not he should be recused in this case. And he also makes a very important statement that they are pausing proceedings of this trial temporarily, which, while is probably the legal right thing to do, kicks everybody in the gut a little bit because delays are not what anybody wants to hear at this point in the trial. So let me pull that clip up. All right, here we go.
And then then transitioning to the last matter the court wanted to put on record, upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it. And until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until this is, they're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point.
So he kind of indicates there that maybe this will happen sooner rather than later, and maybe even it'll be taken care of before Monday when the jurors are supposed to come back after the 4th of July holiday. What are your thoughts and comments about the Supreme Court's ruling on the writ? Because they did not recuse him. It wasn't technically a big win for the defense, but they did enough, obviously, to push Judge Glanville to make this decision to let another Superior Court judge. Now, this is somebody that works with Judge Glanville and will know Judge Glanville, so that will help him a bit, I'm sure. But they pushed him enough to make this decision that somebody else is going to make a call in this case.
Well, first off, the writ of mandamus that went to the Supreme Court threw it out on technical grounds, saying that it should have been filed in the Superior Court first. They didn't follow the proper procedure, all that stuff. And they didn't have to say this, but they did. That if they do file it before Judge Glanville, he has to assign another judge to hear the writ of mandamus because the respondent, in other words, the defendant on the writ of mandamus, they're called respondents on writs. The respondent would have been Judge Glanville. So since he was a party, another judge has to hear it. That was a signal to Judge Glanville that somebody else needs to hear this, because if he files a writ of mandamus, he's going to have to send it to another judge anyway. So he got a clear message from the Supreme Court.
Right.
Okay, I wanted to go over that part that the fact that they did write in saying that it will have to be a different judge that reviews it, and okay, as Shan did tell me, they were a father-son thing too, but as the lawyer, father said, that's his dad, right, Shan? I feel like he said, "What do you think, Dad?" That's what I feel like I heard him say. But he was saying that they don't have to write that phrase in there, but the fact that they definitely did write in that another judge needs to review this, I do think that is a very clear message, and that's important, especially if that's not standard that's in there. Yes, this is for the recusal, right? Yes, so they're reviewing the judge going through him announcing that, court's on pause, it's going to be another judge deciding this and all this stuff. Yep. Okay, so I just thought that was interesting because for him to point out that that's not normally written in there, that it needs to be another judge. I feel like they're, one, trying to keep that judge out of trouble, and two, like, we are looking for this, and it really did, I guess, get denied over a possible just technicality because it didn't go to the right court for the appeal. So yeah. Okay. Shan said Judge Edwards recused herself from the writ on Monday. It's going to have to go to another courthouse. Okay. Sorry, I'm trying to make sure this audio is good quality. So.
And Judge Glanville is going to do that at this point, and he is going to let another judge take care of it. He's not going to fight it anymore. He's not going to. And another reason is the Supreme Court's basically saying it should start here. This is where the writ should be filed before it gets to us. That's kind of the technical part you're talking about, which is fine. It's not a loss for the defense. Technically, it ends up being a win because they do want. It's not a home run, right, where he just gets recused and they get to do this the way that they want to. But at the very least, another judge is going to look at it and hopefully bring an unbiased view and opinion on to what should happen next. And all of this really boils down to an ex parte, quote unquote, secret meeting between Judge Glanville, prosecutors, investigators, Kenneth Copeland, who was a sworn witness at the time, and his stand-in attorney. So the big fight.
Go ahead. No, go ahead.
The big fight has been around this transcript. What was said, what happened, and Judge Glanville said he was not going to release the transcript. Then he was going to release it, but he was going to redact the privileged information. Nobody could really figure out what would be possibly privileged in this ex parte hearing. So now there's been another hearing where Judge Glanville has made a decision on what he's going to do with that transcript. Is he going to release all or part of it? What is privileged, if anything? And what does he want to take judicial notice of? Because all this is really important because we are also supposed to have a show cause hearing for anybody to come out and say, whoever was in that meeting, come and tell me in the court that you didn't tell everybody what was going on in there, because that would be a really bad thing. And I may hold you in contempt. I may sanction you. I may throw you in jail. Well, all that becomes moot if he releases the entire transcript, right? So that's why this hearing is kind of important here that we're going to listen to next.
Well, and what he said in other portions of that particular hearing was the name is going to be put in the normal course of events. It's going to go on the wheel, which means a random selection of a judge that's going to hear it. However, there is an argument that the JQC, the Judicial Qualifications Commission rules in Georgia require a judge from another circuit to hear it, since he's the chief judge of that circuit. So there's going to be an argument about even which judge is actually going to hear this.
I mean, to me, that just makes too much sense. Like, obviously, it should not be a judge in his jurisdiction where he's the chief judge. That seems obvious to me, but common sense and the obvious answer doesn't always end up being right in law. But we'll see. At the very least, some other judge other than Glanville is going to take a look at this. And I don't think they want to be stained and throw themselves under the bus for Glanville if they really think he did something wrong. So we're going to hope the judiciary is going to make the right decision, whoever ends up getting called up. But I think I agree with that, and I love that idea that somebody outside of his jurisdiction will make the call. Okay, so now we're going to transition into the hearing where they discuss the transcript.
As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript.
So right off the bat, first thing he says is, we are going to release the entirety of this transcript. So what does that tell you about privilege and what was potentially going to be redacted or blocked from the public or from the defense attorneys?
There is nothing privileged. Nothing needs to be blocked. Everything that happened at that hearing, the defense lawyers can know, and they could have heard, and they could have been there. And these, I guess it's been 2 weeks that we've been dealing with this. I think it was the 12th that he had that first hearing. In the last 2 weeks have been a total waste of time. And he could have released the transcript, told everybody he was going to release it on the first day, and it certainly would have shortened the process.
To me, all it makes me think is he didn't fully remember what happened in the hearing. So he wanted to take a look at it himself and see how bad it was potentially, and if there was any way he could have blocked anything. But overall, I mean,
I was waiting on them to jog my memory. That's important because, yes, if y'all recall, he did not want to release the transcript either. And I agree with the lawyer, that's on top, that he did want to review that transcript to be like, all right, what are we saying there? What are we saying there? And I don't know, because I didn't get to finish the whole video, if he's going to go over the whole transcript in this video. But I did watch a video where they pointed out a couple of things where it seemed like when the transcript was released, it was jumping conversations. Like it was, they said redacted, but I always did think redacted meant that things were blocked out, not literally deleted. And then it just seems like this paragraph definitely started right before this paragraph, because that's what the copy of the transcript I saw kind of looked like. And I saw it through someone else's YouTube, but that's crazy. So I didn't know. And the redacted could be a general term, and then I'm just used to seeing it where it's actually blacked out and stuff like that. But I was like, especially in court, I thought you just block out stuff that you don't want to have to be seen, not that you delete it. And then it's like, it looks like nothing ever was there. So that was interesting to me. So I'm curious to see what else they're going to say. He's not going to be reviewed in court, just released. Waste of time and money, in my opinion. Okay. Right. That's why this is good. This is a good to look at, because like he might have forgot, but like, did something not follow the rule besides the fact that we had a sworn in witness for this ex parte? Like what was said?
we're going to dig into the details, and there are some pretty shocking, horrifying, terrible things that happened in that hearing with respect to a criminal defendant's rights. But most of the gist was what people were reporting and talking about happened in this hearing. But we're going to get into the details once we get to the full transcript. But let's hear him take judicial notice, make a couple other decisions that are very interesting as far as what's going to happen now.
Of those proceedings as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that will be marked as courts 2. So the transfer will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt. Mr. Melnick.
The timeline is important because he was granted immunity before he pled the Fifth, which is why he was thrown in jail. If that would have been backwards, it may have been different. We'll get into that a little bit more as we read the hearing transcript.
Informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Caleb Bumpus, attorney or ADA, Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival.
All of this, by the way, is noted in the transcript that we'll look at too. When they took a break, when the court was in the room, when the Kenneth Copeland was in the room, because he was not in the room for the entirety of the hearing in the transcript, which we'll see.
The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were Attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, Deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall.
It's a bunch of cops. It's like 4 to 6 cops standing in there with the judge and a couple prosecutors with Kenneth Copeland. How do you think he felt? Do you think there was any coercion? Do you think there was any pressure? Or do you think he just felt free, like he was represented by his lawyer and he could say whatever he wanted to? Right?
That was the whole idea. I mean, it was designed. These things are designed this way. I mean, that's the whole point. And there were people in there that didn't have to be in there, but they were all in there.
Be there, but the defense didn't have to. It's crazy.
No, I'm talking about there are investigators. They just packed that room.
Right.
So that was the other part, because I had watched this section before, that the dad is saying, that is standard, but just to point out that even more so, there was a reason that Lil Woody, aka, or it was really Copeland, aka Lil Woody, was in there with investigators that didn't have to be in there. Like he said, officers, all these things that really didn't have to be in the ex parte meeting, but they were there to, intimidate. Like that's what, and he said that's what happens all the time. But that just goes to prove even more like why the defense wasn't notified, so that was interesting to me. Oh yeah, Bumpus saying she was on camera in the hall talking to the defense. I did hear that come up. Right. Greta said this judge is not it for this trial. I did not see him as partial or fair. Greta said, actually, I just do not like this judge. Seems he already made up his mind on the defendant's guilt from 2013. Okay. He's definitely not, he's operating out of a lot of privilege. I will say that. I mean, I didn't even know everything. And I'm like, it's feeling like no one should question you, period. Yeah, Sweet Jane. Woody got on my nerves too. I giggled a couple times, but he did. He was like, okay, Woody, come on.
The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with Attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams.
Oh yeah, we don't want to forget that.
The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor, entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Brian Steele, in open court upon information and belief stated to the court, which are still on.
This is all for his order, because he's making an order, releasing the transcript, wants to give the timeline, and wants to say now what Mr. Steele said and take judicial notice of them.
Known. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which of course already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said. So the court is paraphrasing the six assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
And these are important for us to listen to these now before we read what actually happened in the transcript in the hearing, because these were Steele's big gripes and big problems. And the court is putting them on the record before anybody gets to read the transcript. So it's important to know what the beef was that the defendant had, because if none of those came true in the hearing, then it would be a moot point. But if they were legit, then there might be a problem, right?
Oh, yeah. That's the whole issue. But again, he has to presume that they're true when he's reading these.
Right.
Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel, that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage.
So he's basically saying he thinks that's when Bumpus told him what happened in the ex parte hearing, right?
Well, that's what he's saying, but later on we're going to talk about it, but I don't think that's what happened.
And only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for
Then why mention it?
the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage, and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any or procedural, substantive, or tactical advantage as a result of the ex parte.
My bad, y'all. I forgot to see. This is why I was double muted. My bad. I was saying that I do love hearing the attorneys listening in real time because they already know the legalese. They're used to the legalese. Can y'all hear me now? Let me make sure before I keep going. Okay, thank you, Divine Virtuous Woman. Okay, so I'm enjoying this because their real-time reactions are really helping me. And they're parsing through the fillers to get to the point, and I really like that. So I mean, obviously that's what they do because they're attorneys. I just want to say I'm enjoying this, and it's helping us catch some things in real time that we may not catch. And yeah, I love interesting people that do this. I have another attorney. Depending on the next thing she reviews, I might switch to her and then switch back to him, or depending on how they review and what they review. But I have somebody else, and I'll go ahead and tell you her name, Natalie Lawyer Chick. She does a lot of sovereign citizen stuff, reactions too. But I believe she's covering this trial too, or at least part of it. So I would like to see hers if she does some other parts of the trial to see her reactions as well, because she stays on point. That woman is quick, and I think she is a defense attorney if I'm not mistaken, so she's really been in that seat. I just enjoy it though. And I have to again break this up, give my commentary, because this is other people's content. This is just me reacting, remixing, and giving my own thoughts about it.
Communication, and the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver, and all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves impertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier.
So just that right there says if the judge inadvertently becomes aware of ex parte communication, you should let everybody know.
Right. That's the notice requirement. That's the way you can cure a lot of problems, by telling everybody, what happened.
Which we've seen in lots of trials. It's like, hey, I just want to put everybody on notice. This happened. You just cure it, and it shows you're not doing anything nefarious. You're not trying to hide anything. You're not doing anything slimy. But he didn't do that here.
Well, like a lot of things, the cover-up is worse than the actual crime.
Exactly.
I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland.
Which is exactly what the defense asked for.
I'll address the issue of the emergency nature of this particular hearing, or this particular conference in front of the court, is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5-507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement.
So he says no tactical advantage, basically nothing the defense could have used, nothing the defense could have learned from being there. It was just a discussion about his immunity agreement and making sure he understood.
Well, what he's doing is he's given his defense, and he's presenting his defense, and he's not presenting his defense for any reason, because his defense is going to have to be presented to the judge that here's the recusal motion. This defense is strictly for the cameras, because there's no reason to do it otherwise.
Right. And we're going to read the ex parte hearing. He knows that. Everybody has the transcript at this time. He knows people are going to disagree with those statements, including us, that no tactical advantage, no pressure was put on this witness. Nothing the defense could use or learn from this hearing. Though that's what he's saying right now, which is just not how I see it, I'll just say.
Consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record. One of them is the United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations, the trial judge may find an ex parte conference necessary. Cite LaChapelle, and that's LaChappell versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about the threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant.
A lot of these are witnesses or jurors wanting to speak to the judge.
And we agree with the First Circuit. The ex parte conference is appropriate in that situation. They see United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And then you've got the citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference with frightened juror properly were transcribed and judges' comments carefully framed. This court goes on to say in Adams, two aspects of this conference are disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed.
Do you see any of these as being the situation we had here?
Well, no. I mean, there's not direct correlation of the facts.
I don't see any of it. I see major differences between all of them.
Yeah, there's not a correlation, direct correlation, but it gives him general propositions of law, which is what he's talking about. That's what he wants to do, is make things sound like there's cover for him to do this.
Exactly. He's saying, like, this isn't the only ex parte meeting or hearing that's ever happened. Right. Happens all the time in cases like this, and the defendant doesn't have to be present. But it's like a jury getting threatened or, stuff happening is not the same as what happened in this case, or a witness even wanting to talk to a judge. That's very different than what happened in this case.
And they also deal with direct threats, which is something we'll talk about when we go through the transcript.
Exactly. I'm going to refill my water. We're going to keep listening.
Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the State, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on the case law, that that this was a proper ex parte meeting pursuant to Rule 2.9, as well as the no party gained any tactical advantage, and that the proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the State. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Steele raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding, which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge.
So, but that the defendant doesn't necessarily have to be there, but his lawyers should have to be there. That's the point of is represented by counsel.
Right. The defendant doesn't have to be there, because if y'all didn't catch it, I'm about to paraphrase, but basically the judge was saying that during these types of things that they did with the ex parte, the defendant does not need to be there because they're not familiar with legal terms. It's not going to serve a purpose. As the lawyer just said, but the defendant's attorney should have been there. Also, did y'all catch what the judge said? Mr. Steele was right. Did y'all catch him say that? Like, baby, the backtracking. Let's see. Thank you, Didi, for the like, number 116, popping your head in. Okay, at the VA hospital. I got you. Okay. Woo, Greta said we were witnessing real-time corruption by the justice system. And see, I feel like this is like a cake batter mixture of so many things. He's used to doing it his way, hadn't really had to refer back to the Georgia rules. Then also, like, there's a lot of eyes on him because of the type of case it is. It's a media circus. There's so many things happening. It's so much happening. Yeah, right. The lawyer needs to be present. But did y'all catch him when he said something about Mr. Steele was right or something? I ain't gonna replay it because y'all can hit replay, because I know we still got some time in this video, and they said they're gonna get to the transcript, so I won't hit replay. But I thought I perked up when I heard that. Okay.
Right. Somebody has to be there.
Right. But he's making it seem like, oh, no, the defendant doesn't have to be there if it's just law stuff that he can't understand. It's like, yeah, if represented by counsel, which would infer that if he's not represented by counsel, he would be allowed to be there, because if his
this is designed for the cameras, because people out there that aren't lawyers are listening to this and they're thinking, wow, you know what, this makes a lot of sense. But when you really break it down, it doesn't make sense. He's just covering himself.
Yeah, I don't know how many people are buying it at this point, but I get what you mean.
It is well settled under the Georgia Constitution, guarantees the criminal defendant the right to be present and see, hear all the proceedings which you had against him or trial before the court. It's Prickett versus the State, 314 Georgia 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow. Takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and or our Supreme Court. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct. The court's basis for having been explained on the record, a written order of this, along with the attachments, will be included in the record. And Mr. Banks, where are you? Sure. As a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024, as I mentioned earlier.
So that's off. That's canceled. No need to have the show cause hearing, right? Because now the transcript is released. So there's no violation because everybody's going to know what happened in that secret meeting, including all of you watching, right? So these people had to hire lawyers. They had to pay legal fees. These lawyers had to prepare for a show cause hearing. And the judge is just like, actually, I'm just going to give out the transcript. Maybe somebody else was right. Maybe I was wrong. I'm not going to say that, but you're dismissed, sir. You have nothing left to do, right? I mean, that's crazy that that's what happens.
They also filed motions to quash. They filed a bunch of other motions. And if you remember at the very beginning of this, Banks's motion for recusal was part of the recusal that he's sending to that other judge. That's going to be moot. But he did mention Banks's name when he listed the recusal motions that he had. So they also filed a motion to recuse him as well as everything else.
Yeah, and it's really crazy to me that this stuff just happens and people have to pay for lawyers and they have to do all this work when they were right at the beginning. And before it even gets settled, they're just like, never mind. But that's just a brutal part of our system. All right, well, listen to the last minute here of this hearing.
We were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that. So we will not be holding that particular hearing. Okay. All right. And then then transitioning to the last matter the court wanted to put on record, upon further review, this court will in fact enter an order sending Mr. Adams and Steele's.
The minute we heard at the beginning, I just want to play that first so we can handle the clip of the fact that he is going to have another judge take a look at the recusal. Any other thoughts on that hearing before we jump into the transcript?
No, but it's interesting that the one thing he didn't do is he didn't dismiss the contempt against Steele. He didn't do that. So that's still out there pending.
That's interesting. All right. Here we go. Transcript of the ex parte hearing, Judge Glanville, June 10th, 2024. So here's present in chambers at this point at 9:10. Glanville, District Attorney Love, Attorney Kayla Bumpus, who is Kenneth Copeland's attorney, reporter. What is that?
Guy cleaning the outside of the house.
Okay, I'll mute your mic and I'll unmute it when it's
go ahead and mute it.
Okay. So present is Glanville, District Attorney for Copeland, court reporter, and 2 investigators at this point. Judge says he's ready. Ms. Love, the ADA starts. That talks about twofold concern. One, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him into the courtroom when the jury comes out. The second concern that I have is I wanted to bring to the court's attention in line with the concern that I expressed on Friday. I don't know what advice counsel may be offering or may be offering. That is their right and their business. So why is that a second concern? That she's worried about what advice a criminal defense attorney is given, a witness potentially looking at criminal implication.
Okay. I'm sorry, you may still be able to hear some of it outside there, but
you can just talk first. You can just talk normal.
Okay. Go up to the top, and the interesting thing is you do not see the judge saying anything before this starts. How is that possible that the judge didn't say anything before this hearing starts? And it starts out, the first person speaking is Miss Love.
Okay, I'm so sorry. I'm finishing up a Starburst. Y'all, Okay, did y'all hear the dad lawyer? He said the first thing that stands out is there at the beginning of the transcript, this ex parte transcript, where they had Lil Woody, the judge isn't speaking. Meaning, where is that section? Because we all know, of course, the judge would speak first. So that's already setting the tone for what's going to be missing in this transcript. He releases the transcript, and the chunks that are out, that are cut out, y'all, that's so obvious to not have the judge. I mean, it's obvious to attorneys. I ain't gonna say like I just caught it like that. No, I'm saying off of what they're saying, that makes sense. Where's the judge's statements first? Because of course he has to commence everything. Like, oh my gosh. Let's see. So Sweet Jane asks, do y'all think it's likely he's guilty or likely not guilty? And she's talking about Young Thug. Greta says not guilty. Divine Virtuous Woman said they may end up throwing this case out, it appears. I'm gonna say, and this is me agreeing with Shan, because again, Shan has been following along well, and of course, you know, she's one of my legal eagles and everything. I'm gonna say that I don't think that, how can I put this? I think it's proven he rented the car that was used. I don't know if they can prove he knew what the car would be used for, because that's so easily traceable too. I'm gonna be honest. Like, why would you rent a car in your name that could easily be traceable to the then crime? So I feel like his hands aren't clean. I just don't know if this one, if there's beyond reasonable doubt that can be proven in Young Thug's part in this. I think that there's witnesses and things to go along with who actually, you know, as far as who unalived the murdered, who unalived the victim and things like that. But I don't know about Young Thug's huge part in this being Rico and everything for him. I don't know. Plans and Penn said, I think he's guilty of some things, but the state can't prove it, and I don't think it amounts to Rico. Okay. Plans and Penn said, yep, either the judge didn't have control of the meeting, which the way he runs things, he probably had control, like he should, or things were deleted. And y'all, it looked like things were deleted. Greta said it's not beyond reasonable doubt. That is why the case needs to be thrown out. The judge may be removed or disciplined by the state bar. Hey, Shirley, how are you? All right. So we'll keep going. But that was interesting. Y'all, listen to their feedback, because they're calling out the things that don't make sense in this transcript.
Number one. Number two, the judge makes no determination as to why this is an emergency motion. Why doesn't the defense have to be here? You know, Ms. Love, before you talk, explain the emergency nature and why the defense cannot be privy to this information. None of that. So we start out with Love, so you know that there was stuff talked about and said before this transcript started. I mean, it defies logic to think that there wasn't. And then you look at these two particular issues. Where is the safety of the witness? They don't really worry about the safety of the witness. They're more worried about the fact that they're not getting their way with the witness because the witness has a lawyer that's not letting them get their way. And so they don't like that. So they want the judge to take care of that. And they want the judge to intimidate the witness so he testifies. Basically, that's what they're saying.
So it also comes down to, he talks about, or she says, as it relates to testifying, I don't believe criminal exposure is a concern. It's like, well, you're the prosecutor. So it's not up to you to advise a potential criminal defendant on what the criminal exposure is. So she is, to me, this prosecutor, as we read this ex parte hearing, does not live in reality. Like, I would never act how she acts, and acts like she has all the power to do whatever she wants. And if she says it, everybody's got to listen to it. The judge, the prosecutors, the criminal defendants, the witnesses, and she just, whatever call she makes is all that matters, which is just not true. And it's not correct. And she misunderstands so many different aspects about how the attorney-client relationship works when you have potential criminal liability.
Well, I've got to, I've been a state prosecutor and I've been a federal prosecutor. She's embarrassing. And I was the chief of the criminal division as well as the felony division of the state attorney. If I had an assistant that said these things and acted like this, I send them back to school. She missed the boat somewhere in her training, and she's, I believe, the chief assistant. I believe Miss Love is the chief assistant
to handle this case, which is a very big case.
Right.
But then
it's terrible.
So then she says, Mr. Melnick relayed to Miss Hilton, which is the other prosecutor, on Friday that he never heard of statute 245507. And on Friday sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele, Mr. Shart, with me and Simone, where he said, this is the communication I received from Miss Love regarding Miss Copeland, Mr. Copeland. First off, I don't think that was a mistake. I think he wanted the other criminal defense attorneys to know what's going on and what the prosecutor's telling him. There's nothing wrong with that.
Well, first off, it's one of the things the problems the prosecutors have is this is a full disclosure. He told everybody what was going on. It was no secret. And the other thing is, think about this. They do an ex parte hearing, and what do? They bash the defense lawyer who's not there and telling the judge, look, this guy is stupid. He doesn't know this statute, and he can't defend himself. He's not there, so they just rip him.
My response was, whose interests are you protecting? Yours or Mr. Steele's? Which client are you protecting? Whose client? Yours or Mr. Steele's and Mr. Shart's? He wrote back saying, you are going to get him killed. You are making him a target. F you, is what he wrote in the email. So again, do we really think she cares about Mr. Copeland's best interest? She cares about her case, what she wants, the testimony she needs, and she's trying to make it seem like he's doing something shady when in reality, the witnesses for the prosecution cooperate with defendants all the time. We talk to prosecution witnesses or defense witnesses all the time who tell us what they're going to testify to, whose lawyers work with them. There's nothing wrong with that. He's not beholden to the prosecutor's office. So for her to act like there's some wrongdoing here is just unbelievable. And then number two, he's basically saying what you're doing is putting Mr. Copeland in danger and you don't care.
But again, he's not there and he can't defend himself. This is an easy hit for the prosecutor.
Additionally, there have been stories that other people connected to Mr. Copeland have not done well since all of this. This portion about Mr. Melnick is also interesting as to whether or not he represented Mr. Copeland at the time. And it comes down to, and what we're going to find out is, he's basically saying if the prosecutors are having these off the record conversations that aren't recorded with Mr. Copeland, it's hard for Mr. Melnick to represent him if he's going to go testify. So if he's going to testify, he's not going to represent him. And the prosecutors are trying to make it seem like Melnick is doing something wrong in that situation.
This is another huge ethical problem for these prosecutors. Throughout this transcript, they admit that they had private conversations with Copeland without his lawyer there. They know he's represented. They know he has a lawyer. Regardless of this garbage about Copeland saying, I wasn't represented, I am represented, the facts are there is a notice of appearance in a criminal case, in a file, where Melnick is his lawyer. Those lawyers are duty-bound to recognize and respect the fact that he has a lawyer. Until the judge releases him from his duties as a lawyer, Melnick is that man's lawyer. And these prosecutors are just outrageous in the way that they're trying to manipulate Copeland to get between him and his lawyer. That's outrageous. Hopefully somebody's filing a grievance against him.
And what else is problematic and annoying is we're going to see in this hearing, and we saw outside in court, how Glanville just wouldn't let the lawyers walk away from Copeland. They basically forced them to stay, which shows that Copeland randomly saying, I'm not represented, doesn't matter. And all lawyers know that unless a motion to withdraw is filed and then granted by the judge, because sometimes lawyers want to get off the case and the judge says, too bad, no, you can't. So it doesn't just go in and out like you're represented by.
Hold on, y'all. I'm coming. Hold on. Okay. Wow. As Bonnie said, wow. Right. I mean, in the little low-level civil courts stuff that we've seen, they're represented until the attorney is motions to withdraw, and then the order is granted. the motion is granted for the withdrawal, they have representation and they know that. And then all these private conversations with someone that's represented is crazy to me. And I believe this is what Shan told me that like for instance, Nasty Nesto, the attorney that Shirley started paying for, but then the funds have been cut off. I think Shan said that lawyer was denied on not representing Nesto anymore. Shan, you still in here? I know you got to go soon, but let me know if I got that right. That lawyer for now, still for a portion, still does have to represent Nesto right now. He has not been released by the judge yet. Let me know because Nesto's attorney, the one that was in the viral video. Yeah, Krell's still there, and the judge forced him to be there. Okay, Nesto's attorney is still there right now. So. Dang, they knew, the prosecution knew. And then I was like, oh my God, he said I was sending them back to school. I don't think they live in reality. Talking about the prosecution. Oh, and then the email, shout out to the attorney that sent the email to the other attorneys, like, you should know about this. And the attorneys that are reacting to this said they didn't do anything wrong. Woody's not on trial, so it would be a little different. He can fire his attorney. Right, I'm not saying he can't fire his attorney. I was just saying that not all times when someone files a motion to withdraw is it granted, but I see what you're saying. Like, he's not a defendant, he is a material witness. So I get what you're saying, but I do feel like, well, that's from what they're saying. So I ain't gonna say I feel like. From what they're saying is there would have been paperwork for them to know if he was or wasn't still represented or not. But I see what you're saying, Shan. He's not on trial though. Got you. Okay, I'm going back. Ooh.
Counsel 1 minute and 1 minute you're not, which is what it seemed like through this. So then they kind of discuss, how long he could potentially be in custody, what Ms. Bumpus needs to explain to Mr. Copeland. Is it the end of this trial or the end of all the trials? Bumpus says she just wants to be able to give him, and the court said, I know. It's kind of a statute. It's kind of the statute says, that you purge, but I can't keep him there indefinitely because, again, they're discussing whether it's till the end of this trial or the 12 other defendants that haven't been tried yet. And then we get into, but what we overheard being said, and I believe this is the prosecutor again, overhearing conversations between Melnick and Kenneth Copeland, attorney-client privileged private conversations that they are listening to. They are going to hammer you as if we're going to expose Kenneth Copeland to. Ms. Bumpus said, you heard that? And Ms. Love said, yeah. Mr. Melnick told Mr. Copeland we're going to hammer him.
Right. And then the court's comment right after that is interesting because the court is actually trying to explain that away.
Now, to be fair, as I think Ms. Bumpus as an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination, which is not what they were saying. And Bumpus said, I think that's what he meant. The court said, he's going to face, he's got about 10. And Love said, so he meant the defense is going to hammer him? Ms. Bumpus said, no, just in general, it's not going to be a, hey, da-da-da. He knew that. He's already been expressing that. Right. But here's the thing. He knows, like only Copeland knows what he knows and what he's going to say and what he's going to testify to. So maybe Melnick knows some of it too. Are we really supposed to believe that the prosecutor's not going to hammer him as well? If he lies or he says something they don't like or he pleads the fifth, he's going to get thrown in jail and he's going to get hammered on direct and he's going to get hammered on cross. None of these lawyers represent him. None of these lawyers like him. So it's a completely correct statement to say the lawyers are all going to hammer you throughout this process. And
right.
That's something the lawyer is advising him of that the prosecutor's overhearing. And she has no fear. Once again, if I did hear this, I would be like, oh, crap. I just heard attorney-client privilege information. I need to let them know that I heard it. I'm not going to use it in any future arguments or against anybody. That's what you're supposed to do. Instead, she just openly in front of the judge is like, Judge, I heard him talking to his lawyer, and this is what he said. I have a problem with what his lawyer advised him of.
See, what's happening here, and your listeners should recognize the fact that all the impropriety that's occurring here is the prosecutor. everything that they're doing unethical, repeatedly unethical things over and over again. The judge's sin is that he's letting it happen. That's the difference. The difference is the judge may not be saying anything that's really bad yet, but he's letting the prosecutor go crazy and act unethically. And he still has not recognized why this is an emergency and why this should be an ex parte hearing.
Yeah. And again, the judge should have just said to her, Ms. Love, that's a privileged conversation. I'm not going to consider what you're saying there. Like, that's what he should say. He should not consider that statement.
Right. Or ask her, why were you talking to Copeland without his lawyer present?
Right.
That's a question he could ask as well.
Then Bumpus says he doesn't know what was said outside of his presence. Again, this is Melnick. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. That's totally fair, right? He doesn't know what his client told the state. He can't advise him, that's a lie. That's not a lie. That could open you up to criminal prosecution. That couldn't, because he doesn't know what's going to be inconsistent. He doesn't know what was happening in these conversations. And also, the state wasn't recording them. That could have been solved. They could have recorded them and then given them to Melnick so Melnick would know what was said, but they didn't do that. Then they start defining what a lie is. And by a lie, we don't mean like, oh, I think you're lying. I would love to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. Tell the truth. I don't care how bad it is. Just tell the truth. And they mean the truth, what they think the truth is. And even Copeland starts to pick up on that. Like, what if you think I'm lying? So they give some examples. Love says there's been an assertion that people are representing that their biggest concern is his best interest, and they're just not here. And Ms. Bumpus is saying she's not in position to do that. Bumpus says, I'm saying the agreement between Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says he discharges Melnick, which again, prior to this point, no discharge papers for Melnick. That's their agreement. I can't do nothing about that. Love said, that sounds weird. It does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I ain't going to. I'm not going to represent you. I don't even know what to do with that. Bumpus said, well, he said he does not know what was said. I think it's totally fair for Melnick and Bumpus to be in this position, don't you?
Well, it is, but Melnick, and the judge will go through this, Melnick, that really is not a good thing for a defense lawyer to say, that they're forcing him to withdraw if he testifies.
But don't you think his reasoning is sound in that if he testifies, the issues that will come up while he testifies, Melnick will not be able to represent him on?
Oh, absolutely. And you might want to file a motion with the judge, asking the judge to let you off the case because of that. But that's what you should do, is file a motion with the court and have the court have a hearing on this information. But you're right. It's perjury, the prosecutor decides what perjury is. And, if they have statements that you don't know about, well, how can you defend your client?
And the issue was created by the state.
Yes.
Having these conversations without counsel present, from my opinion, those conversations should just be struck. They should not be able to impeach Mr. Copeland based on anything that happened in those conversations. There are ways to fix this where you could force Melnick to stay on. Meaning anything you don't know, Mr. Melnick, or you weren't there for, can't be used against Mr. Copeland. That's a fair remedy to me.
Except the judge cannot control what later on the state attorney may file a charge of perjury.
Correct.
The judge can't control that. He can control what happens in this trial, in this case, but later on, if there's a charge of perjury, the judge can't stop that.
Right. But what he can do is say you can't use that stuff. And if you are going to use that for a crime of perjury, then you're not actually giving him the proper immunity. So I'm not going to throw him in jail for contempt for not testifying. The judge can do that.
I don't know if he can. I'll be honest with you. I don't know if he can interfere with prosecutorial discretion.
But you think so? The judge has to throw him in jail if he won't testify.
I think if he keeps the fifth, yes, the judge has to throw him in jail.
Oh, I don't think that it's that black and white that he would be forced to do that.
I think so.
Okay. So next, Miss Love says, Copeland was like, hey, he's not my lawyer. I don't have a lawyer. We've already kind of heard some of that. So then we get to the fact that Ms. Hilton had a list of questions for Mr. Copeland, which I thought was interesting. And again, something that if defense counsel was in the meeting for, they might want to know. Ms. Hilton already shared the list with Mr. Copeland, and they'll share it generally speaking. Can I read this email Melnick sent? Can I read you this email Melnick sent me? I don't know if it'll help you understand what he's saying. So that's just more about what I'm saying.
Can I just raise one thing about that?
Yeah.
You see that where the court says, I thought that Ms. Hilton had a list of questions for Mr. Copeland.
Yeah.
Maybe I missed it, but I went back in his transcript. I don't see where the judge was told that in the transcript. So there must have been a conversation outside of what's in this transcript where they told the judge they had this list of questions. So that's another clue that something else went on before this transcript started.
And I think they've had hearings and talked about Copeland a lot throughout the trial, like even outside of this with the defense lawyers there. But the defense lawyers will know because they've been there this whole trial. They're going to comb through this and pick through this. And if there's more indications of that, there's going to be more problems. Ms. Love said, so he can't force Mr. Copeland to discharge him just because Copeland decides to testify. The court said, I think you are in until it's done. I mean, you know, and Bumpus says, who, me? The court basically says he's going to force Bumpus to stay on. And Ms. Love said she's in a tough position because she's not the one that interjected herself. Melnick is, and now she's standing in for Melnick. And they talk about the immunity agreement and how they're not going to use anything he says against him. They're not going to prosecute him for anything that he says. Of course, later they say, well, if he makes up
real fast, those outside conversations the case, the trial is tanked at this point anyway, but these outside conversations that they admitting to, it's on transcript. And since they did delete some things, they forgot to maybe delete that, or they didn't realize other people will understand the context. Hold on, y'all. Sorry, I meant to mute myself too. I had to yawn. But you can't delete everything. Oh, this is bad. Can they force? Oh, Divine's saying, can they force? Because Shan said to me, this is the definition of force. That's probably why this is coming up, because I don't think you can. I don't think they can in the manner that they are, because there's always some kind of workaround caveat, but I think this was not it. I don't, you know what I mean? I saw something when we were looking up the definition of a hostile witness. It seemed like it was something to do, like at those times you can kind of, in certain ways, up to a point, an ethical point. So I don't know though. I feel like that starts to be possibly wordplay. I don't know. They can make things very uncomfortable for people, it seems like, and then that's still a type of force. I don't know. I'll wait for my legal eagles on that one.
certain lies that could change, which we'll talk about. You're his lawyer. You're his stand-in lawyer at this point. Judge is going to force Bumpus to stay on. Love said we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded, again, as long as it fits the state's narrative. They basically qualify all their immunity in that. Do you think he's fearful of testifying for other reasons like personal safety? Bumpus said right. Love said that is what Mr. Melnick said to me in an email. I can pull it up. You're going to get him killed. Again, we already talked about that one. But again, there are other things going on and other reasons he might not want to testify. Then Glanville exits at 9:33. Love says, we just like to go into another courtroom and talk, give you a chance to talk to him, meaning Bumpus to talk to Copeland. Glanville comes back 1 minute later. Miss Hilton has been communicating with him. I'd like to grab her as well. So Miss Hilton's going to join the party. Then they come back basically at 10:03. So they're in recess from 9:34 to 10:03. Again, while all the defense lawyers are just waiting out there. And who is now in the meeting? Glanville, 2 district attorneys, court reporter, 2 investigators, Deputy Houston, Deputy McPherson, Sergeant Brown, Sergeant Hall with the Fulton County Sheriff's Department. So 4 more officers. So now we have 6 officers, 2 district attorneys, and a judge in there with Mr. Copeland, as they're about to explain to him how bad this could get for him. Let me see something here. All right. So page 24 is when I want us to start reading a couple pages here. We'd like to hear your testimony. That's kind of where we are at this point. So is there anything you want to ask? So now Copeland's in the room. I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. So just that statement right there. If the defense counsel was in the room and he said this on the record, and now they have it, and I guarantee they're going to use it, is this not impeachment material for this witness that the defense is absolutely have a right to?
No, absolutely. The fact that he is that he doesn't want to testify. How many times does he say that? The fact that they have to keep threatening him. All that stuff is useful for cross-examination.
But specifically, if this is the state star witness and he said he's never been truthful a day in his life,
oh yeah,
that's pretty important for the jury to hear.
But apparently nobody else in that room thought so.
Right. There's no tactical advantage. There's nothing the defense could have learned or used in this hearing at all. Totally fair game.
Can you imagine a prosecutor not using, if a defendant ever said, I've never been truthful a day in my life? Can you imagine the prosecutor saying, oh, that's not important. I'm not going to ask you that.
No, I don't need that to prepare for trial.
Right.
Okay. Well, the only thing you can give is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it. Hilton says, and what we'll say, and Mr. Copeland and we have talked about this. I'm not sure what your concerns are, what concerns you expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up, you can't. Like, there's nothing that can happen. The feds, and Bumpus said, well, that's not, and Hilton said, it is true. Bumpus says, no. I said, that's not his concern. If his concern is safety, we need to know that. Like, that's not expressed. So we don't know what the concern is, so we can try to resolve the concern. This is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concern is potential criminal liability, hence why we gave you immunity. The federal statute of limitations is done. The state statute of limitations, done. So there is nothing, like I researched it this weekend, but those statute of limitations for what you and I talked about, which is 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that is the concern, there is none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been in 2020. Anything statewide, 4 years would have been 2019, finished. Next concern, what may happen in the street. You know what we have talked about, what we can do as far as living and all of that. We have had those conversations. So I'm trying to express to you, we do not want you locked up. I don't know how many times I have to tell you that. What I've got to say to you, we do not want you sitting in DeKalb or whatever they got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Miss Bumpus, I'm here. This is a prosecutor saying, if you want to talk with or without your lawyer, I'm here. But we do not want you in custody. Go ahead.
Let me go back.
Okay.
The federal statute of limitations is 5 years. That's a lie. There are crimes that are 10 years. There are crimes that are 20 years.
What she's talking about. Do you?
No. And in fact, is she's giving him legal advice.
Correct.
She's becoming his lawyer, and she's lying to him, totally misleading him about the statute of limitations on federal cases. I mean, you know, she's a lawyer. She can go look it up. Where did she get the 5 years for all federal crimes? I mean, it's absurd.
Are you saying there's not a single federal crime that's got a 5 year statute of limitations?
Sure there are, but that's not all of them.
But she doesn't say all of them.
Yes, she does. She said he cannot be prosecuted. Said, don't worry, because there's no federal prosecution because the statute of limitations is 5 years. That's what she's telling him.
She said those statute of limitations for what you and I talked about. So I think she's saying she looked up the specific crimes that he told her he committed, and she's saying those are 5 years. She could still be wrong, but I don't think she's saying all federal crimes.
She is wrong. I'm just telling you, she is wrong.
Okay. Well, here's what I'm saying. You're 100% right in the fact that she shouldn't be giving him legal advice. And if she turns out to be wrong, like you're saying, and he does admit to something in the feds prosecute him, guess what? Too bad, so sad. You're going to prison because this doesn't hold. If she's wrong, he's the one that gets screwed at the end of the day, not her.
Right. And it's not his lawyer telling him that. It's the state becoming his lawyer.
Yeah, it's horrible. It's horrible. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Ms. Bumpus, as I told you, that's what the order says. And that is direct or cross, the judge pipes in, and that's direct or cross. So if you are worried about the defendants, they may ask you because they may know your business, but if they ask you about things that you might think you have some liability with, you can't be prosecuted for any of those. So that's even more wrong, like you're saying, because now they're saying crimes we don't even know about. And they're still saying those statute of limitations. So you're right. Mr. Copeland, I got family members watching this trial. I don't want my nephews to hear the things that I may be involved with and think it's okay. Ms. Hilton says, but I think that's a separate conversation you have with them as an honest individual. Like, look, nephew, I've lived through this life. I don't want you to live. Don't go through what I've been through. Again, pure legal advice, pure coercion, pure just telling him exactly what he needs to do and should do, forgetting about what's best for him.
Can I interrupt for a second? Maybe I missed where you read close your ears. Did you read that part?
Have we gotten there yet?
Yes, the page before, page 26. And that you will not. Yeah, there you go. That paragraph.
You will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, any of it, literally. Judge, you might want to close your ears. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. So the facetious close your ears, which again, these prosecutors have no fear that the judge is going to do anything that encumbers what they want to do and what their end goal is. They know this judge is not going to reprimand them. They know this judge is not going to tell them they're doing anything wrong. They know this judge is not going to shut down this, interrogation and threaten fest that they're having with the witness. This is just proof of that. And again, we all know there ain't.
Hold on, y'all. I keep opening my app on accident. Oh my God. Judge, you might want to close your ears. They too comfortable. They are too comfortable. And Shan said this should have been discussed when they talked to him. Did they prepare or even talk to the witnesses in this case? It's looking like no. Wow. Yeah, they too comfortable. Judge, you might want to close your ears. No. Y'all outside the judge's chambers, and you letting that dynamic go ahead and seep through. This is, and they kept that in because like we have established things have been deleted out this transcript, and they kept that in the transcript. I agree with the son. The state knows the judge will allow anything. Valencia said, "I agree, but that's because they all appear to be corrupt." Oh God. Hey, close your ears. I'm gonna do whatever I want. Just close your ears. I'm gonna say whatever I want to say. Y'all just close your ears, okay? Wow. Oh, the audacity.
So the advice she just gave him prior is obviously wrong when she's giving this as an example. I mean, that's crazy. Could you imagine a defense attorney being like, Judge, close your ears?
So a defense lawyer would be arrested if he did this stuff. Defense lawyer would be in jail if he did this stuff.
Copeland said, y'all did this intentionally. She said, no, we did not. You and I had this conversation this morning. Again, all the conversations they had. But what did I tell you when we met with each other? I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And I said, if you plead the fifth, and that's exactly what you did on the stand. So again, this also reminds us, and we think back to the defense saying they knew he was going to plead the fifth. And Copeland says multiple times, I told you I was going to plead the fifth. But then it seems like Hilton thinks she talked him into testifying by threatening to throw him in jail if he pleads the fifth. Then he still did it. So they knew it was an option, but they didn't think he was going to plead the fifth. I told you every day I was pleading the fifth. No, you didn't. I told you my concern.
Let me stop for a second. These things now, credibility now comes into play. Who do you believe? Do you believe the prosecutor who said he didn't, or do you believe him where he said he did? And if you remember, the defense during the hearing said they put him on the stand knowing he was going to claim the fifth. And they say, no, we didn't know he was going to claim the fifth. And he's saying, I told you every day I was taking the fifth. So this is totally inconsistent with what happened in the courtroom when the prosecutors were making their allegations about whether they knew or didn't know he was going to take the fifth.
I think it's pretty clear that they knew at some point he was going to plead the fifth, but I do think they have an argument that after they threatened him and coerced him, he said he wasn't going to plead the fifth. He said he was going to testify, and they believed him, and then that's why they put him on the stand. So I do think there's at least an argument for them there.
But who's telling the truth?
Go ahead.
Who's telling the truth?
Right.
Copeland, who never told the truth in his life.
Exactly. The judge is probably not going to believe him, rightfully so. This week we first met in the car on Friday. First met you in the car on Friday, which again is like, what? Is Mr. Melnick your attorney? You said he's not my attorney. I haven't even talked to him. No, I never said he's not my attorney. I said I haven't talked to him. So again, by the way, waivers of counsel and all this stuff and firing has to be unequivocal. Usually there's a colloquy with the judge so that we don't have this exact issue, because this exact issue is usually read in favor of the layperson criminal defendant who has a right to counsel. We believe that your truth is your truth. We know what you've said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. That's Ms. Hilton. They talk about immunity some more. The immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. So even Mr. Melnick told them officially Copeland is going to plead the fifth.
So how did they know? How did they think that Melnick? How did they think Melnick wasn't his client? If Melnick is sending him emails, they're responding to the emails by filing an immunity claim. How can they claim Melnick is not his lawyer?
It's just basically whatever suits them, whatever's better for their case at that point. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point, we gave him immunity, again, responding to that, responding to Melnick again as his lawyer. He could plead the fifth if he didn't have immunity. The immunity is what gets rid of the fifth, because you can only plead the fifth if you are doing something that could reasonably incriminate yourself. And if you have immunity, then what you're saying is not going to reasonably incriminate you. We've talked about this in other cases. If you testify, you get out of custody. You stay out of custody until you're done. And if you don't testify, you have to stay until when? And again, this is when they go over the 6 or 12 other defendants that they still have to try, so he could be in custody for a long time. And this is the judge getting involved as well, telling him exactly how long he could be sitting in jail. I do want to read this page. Ms. Bumpus, so explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? If he says he did something, he did not do that thing. If you believe he did not, so if you believe that he's lying about that, then no. If he admits to doing something on the stand, and he did not do that thing, I'm going to say, is this the first time you're saying that? And we have independent evidence to prove that it wasn't him. Then what? Then nothing. What do you mean? So then he will be fine. Yes, but. So you're okay with him if he got on the stand and said things that weren't true. So she basically said that she's okay with it. But then when it's confirmed, she says, no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. So she's just speaking directly to the defendant or to the witness at this point. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that's inconsistent with what you said before, I'm going to ask you about the inconsistencies, but I expect you to tell the truth.
Just as a note, as a prosecutor, whenever I had a witness with immunity or anything like that, the last thing you always say is, the only thing I want you to do is tell the truth. Because during cross-examination, you know that a defense lawyer is going to say, well, what did the prosecutor promise you? What did they tell you?
Yeah.
So that you always have that statement, well, the prosecutor told me to tell the truth. So that's a statement you always make sure is in there preparing for the defense cross-examination.
All right, so then we get to Mr. Copeland. If I'm saying something different, right? So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Okay, so you can say, I don't recall. It's from the state. That is how that works. I don't recall. The state literally telling him how to testify as a witness, which is very interesting. Ms. Bumpus, and he can say that to every single question. I would hope that's not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is if he says, I don't recall. What will get me locked up? What did I tell you? I don't know. What you did on Friday, I plead the fifth. If the court instructs you, so the only thing that gets me locked up is pleading the fifth. Yes. The court instructs you, you need to answer the question. You say, I plead the fifth. Again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up. Mr. Copeland, so if you don't want me in jail, why you just don't let me go after the trial is over with? You are in jail because you are not answering the questions, because you have been given immunity. The judge piped in there. Because you've been given immunity, you're only in jail because you got up here. Well, what about this? I answer the questions, you take away immunity, I answer the questions, and I plead the fifth. He doesn't want immunity. He just wants to plead the fifth, which I think is very interesting. But one of the other issues I see here as well is she is not just giving him immunity. She is guaranteeing him immunity in every sense of the word, which she cannot do. She is telling him how to answer the questions, and she is telling him what is going to happen regardless of what his answer to the questions are, which she can't possibly do because she doesn't know what's true. She doesn't know what's false. She doesn't know what he knows. She doesn't know what he doesn't know.
Well, the point is, she's giving him immunity. And again, I think I said this in the last video we did before. Giving somebody immunity and not knowing what they're going to say is just incompetence. I mean, it really is. You should definitely know, what is this witness going to say that I'm giving immunity for? Because again, as he claims here, he flat out says, what if I say I murdered somebody? Or, he flat out says that. They said, don't worry about it. As long as it's the truth, you don't have to worry about it. That's crazy.
So then Copeland says, I won't plead the fifth to things that don't incriminate me. The court said, and here's the court jumping in, the state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent, and that Miss Hilton is telling you is just the truth as you know it, and let her worry about, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. That particular false statement. And Copeland says, that's what they're going to do. That is what I was saying. You will be right back here. But if you say something that you know you did not do, like you admit to something you know you did not do, like murder, don't have no statute of limitations, right? So he is correcting the prosecutor on some of the stuff she says. But if you didn't do it, I can't charge you with something that you didn't do. I don't have any other evidence but you saying it. Well, a lot of times that's enough evidence or close to enough evidence. But y'all don't you can charge him with false statements and he will be back in jail. That is what I'm trying to say, Ms. Bumpus says. But and this is back to Ms. Hilton, but if I know you're lying about that, I do not intend to do that. So she's saying if he lies and says he commits even the ultimate crime, if she thinks he's lying, she's not going to prosecute him. So it's totally up to her discretion. So she totally could prosecute him for it. So that's not an immunity agreement. That's her saying, I'm going to choose what I do and don't charge you with based on what you say, based on if I think you're lying. I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you're trying to say you did now. And that can be part of this. I know you didn't do it.
Okay, so are we all on the same page that we now for sure understand why Lil Woody acted the way he did on that stand and wouldn't answer these questions? Because the ambiguity of it all, and then forced to be there almost without representation, this is crazy. Sweet Jane said, child, yes. Wow. I'm sorry. I get why he answered how he answered. I get the delayed answering, the asking to be clarified on things that normally we know what she's asking, self-preservation, CYA. And the beginning is bad. The way they even started this is bad. He already has said in there he was not trying to testify. He was playing as if he suddenly got dementia. Yes, Valencia. Ooh, I thought he was just, I mean, anybody can be a difficult witness. So I thought it was just his type of personality, and that's just how he's going to be on the stand. But to see this transcript from the little they still kept in here, because there's deleted sections, I get it. I get it. Wow. He's still a terrible person. He did some crazy things, but him being on the stand and answering the prosecution how he did, I get it.
So this is the prosecutor now judging the credibility of a witness, basically saying when he's lying and not lying, basically entering the province of the jury, because this is what the jury is supposed to do. But it's up to the judge to do that. No, it's up to the state to bring charges. I don't have anything to do with that, the judge says. He has nothing to do with bringing charges. That's up to the state of Georgia. Then Copeland says, can I call? Can I talk to my family? I will make the decision right after I hang up the phone. He's saying he hasn't been able to speak to anybody, Bumpus said. His sister just called us, Hilton said. Copeland said, y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number, nothing. We have no knowledge. We did not know that he hasn't been able to do anything or speak to anyone. The jail system down, but y'all still putting people in. Ms. Hilton said, that part I don't know. I know we have been in communication with your sister, and your sister actually texted Miss Lassequat, I don't know who that is, to make sure you were okay. We told her physically we had laid eyes on you.
I just want to make sure that, again, viewers know, the fact he got no PIN number, the PIN is necessary to make a phone call. It's a code that they give inmates so they can make a phone call so that it gets charged to their account and that they know who they're recording when they make that phone call. And that's why they enter a PIN number. So what he's talking about is he didn't have the ability to make a phone call because they never gave him his PIN number.
Then he says, I'm talking about locking me back up. We would have to bring charges. There would be no incentive. Y'all will. We've already had this discussion. Look what you did to me. You waited till Friday to do this. I done told you every day before Friday I was pleading the 5th. So again, he says he was pleading the 5th, and they screwed him by making him stay in jail all weekend. No, you didn't. As a matter of fact, our last, Mr. Copeland, this is the court jumping in. Let's see if we can get beyond this, okay? Beyond what your concern is. So this is the judge stepping in, trying to ease the witness's concern. You could have invoked your Fifth Amendment privilege. The state could have turned around and said, stop, had me go ahead and filed the motion to give you immunity. It was going to, they make that decision. They decide on a Friday. He's saying, so that could have been procedurally how it happened, but instead they just went ahead and gave you immunity. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they do you invoking your Fifth Amendment privilege, so they give you immunity. So they gave you immunity, so you've got to testify.
Now, right there, 44, if you go up a little bit, that's where the court steps in and starts going through the actual immunity order that he entered, giving him immunity. And he explains that order in detail to Copeland. So this is the court speaking now.
Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says in the order. The only thing that will get you in trouble is the next little paragraph. Kenneth Copeland shall be subject to prosecution or to penalty of forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. So that's pretty much exactly what he's worried about, because all he does is lie, which is what he said.
And by the way, there's nothing wrong with a judge reading an order to a defendant. That part there, that made sense that the court was actually telling him what the order said.
I think a lot of what the judge did in the hearing makes sense if the criminal defense attorney was standing right there.
Yes, absolutely.
Right? What the prosecutor did, I think the criminal defense attorney would have blown up and been just horrified. But what the judge did throughout here, and what he actually said, maybe what he didn't do would have been problematic, but what he said, I don't think he would have said any differently if there was a defense attorney in the room.
Right. And that's us trying to be fair, and balanced in how we're explaining this, and that the judge's problem was he was asleep at the wheel when this was going on. There are things he should have done and didn't. His was basically a sin of omission, of not doing what's right. The prosecutor, that's a sin of commission. They committed repeatedly ethical violations and legal violations during the course of this, and the judge should have held them accountable and didn't. And that was the judge's problem, was he sat on his hands and let the prosecutor get away with whatever they wanted to get away with.
So the prosecutor then says, but what I do expect for you to do is answer questions so we can get through this, so you can go home, be with your baby for her birthday, see the dogs deliver their babies, go talk to your nephews, and do all these other things. Does that sound like coercion to you?
Sounds like trying to influence, yes, rather than just explaining the order. That's fine.
And
going beyond that, that's a question.
And he says, how do you know about my dogs? She says, because you told me. He's like, okay. Bumpus says, what's wrong? And Copeland says, I'm stressing at another level. Like, Bumpus said, I mean, Copeland said, I'm weak, man. I'm not playing. I'm dead serious, man. Like, Hilton says, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And, you have to make, and Bumpus says, if he decides in 2 weeks he wants to testify, then what? Hilton says, if he wants to stay in jail for 2 weeks, then I don't know why you would want to stay in jail for 2 weeks. I have no idea. Bumpus says he just feels like he's under a lot of pressure right now, this second. Even at the jail, they are just, you can't give me house arrest. Hilton said, no, you can go home by taking the stand. And the court said, and come back tomorrow. We keep on saying yet, but there's no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You haven't done anything wrong except for, so why am I in jail? Copeland says, because you aren't testifying, but that ain't nothing wrong. It's not a crime. It's not a crime, but you're in civil contempt. So now they're trying to explain to him the difference between a crime and civil contempt. Were you going to say something?
No, I'm just looking
at you. Then he explains again why he's in jail for refusing to testify. Copeland says, you can't just sentence me. And Bumpus said, there is no sentence. Court says, there is no sentence. Contempt is compliance. They want your testimony. That is all they want, whatever that may be. I don't know what it is, Your Honor, Copeland says about his own testimony. Hilton says, so listen, you're in jail for failing to testify, not for anything else. There is no crime. You ain't done nothing wrong. I don't know if people are telling you what we are going to charge you with. Nothing. We are not charging you. The state charges you. There's nothing we're charging you with. You are only in custody because you've decided not to testify. That's it. And we got to remember, all this happened after he said potentially he would falsely say that he committed a crime he didn't actually commit. And
also notice what's missing here is fear of his life or fear of some kind of retribution. That's totally missing in these arguments. They say, oh gosh, he's in fear of being killed for this. Well, if I look through this, the prosecutor doesn't give a rat's about that. They didn't mention it once when they went through here, and he doesn't mention it either.
Yeah.
And that's going to be important later, because that's going to be the defense here of the judge and the prosecutor, is that this had to be ex parte because of the fear for retribution for what was going to happen to him if he testifies, yet they really don't deal with it.
Yeah, it was really just more of talking him into testifying, giving him all the reasons why he should testify, what he can say, what he can't say, how he should answer questions, and how no matter how he answers, they're not going to prosecute him. That's really what it's about.
Yeah, and the only thing he's scared about is being prosecuted. That's it.
Right. Actually, just being thrown in jail.
No.
Then they get into how he can purge and get out of jail, and he explains how purge means you do what we want you to do and you get out of jail. And he talks about how it's different than perjury, and the judge kind of explains that to him. Bumpus says, you've got to make a decision. So if he starts testifying today, he's going home today. Hilton said he should as long as he remains. But if you get up there and be like, if you don't get to testifying, and then we get into, you start saying, I plead the fifth, we're going to be back here again. Bumpus said, but if he says he don't recall to everything, he'll be okay. Hilton said, I'm not advising that, but so long as he answers the questions, that's fine. And Copeland said, I did these crimes. I'm telling you that. So again, a statement that a witness makes that is incredibly important to the defense's case and potentially exculpatory. This is Brady information. And guess what? If he goes out and he takes the stand and he does not admit to crimes and he says, I didn't do them, this is a statement under oath the defense should be able to impeach him with. Like, this is important. And I realize this witness on the stand is a little bit, and he's got some inconsistent statements and some issues, but this is still important for the defense to have. This is like the definition of Brady material. Okay, I don't know what you're talking about, but I think, so he says that I committed these crimes. She's like, all right, I don't really know what you're talking about. And Bumpus said, I think, or what you're saying is you're going to get up on the stand and say something, and Copeland has no response. And Bumpus said, did we find out if he could talk to his family? Hilton says, I mean, if it's okay, we got his sister's number. As my attorney, you gotta let me, if y'all want to talk, let me go somewhere where I can't hear you. Oh, that'll be a change. They're not going to overhear conversation between him and his lawyer. The judge is over there, so just speak low so he doesn't.
Okay, real fast. Brady material, because he keeps saying, oh yeah, that's not Brady material. Brady material, or the evidence the prosecutor is required to disclose under this rule, includes any information favorable to the accused, which may reduce a defendant's potential sentence, go against the credibility of an unfavorable witness, or otherwise allow a jury to infer against the defendant's guilt. So that's Brady material, just in case. I was like, it's a little buzz term I keep hearing. Let's go. What is this? Okay. We'll keep going, but I agree, Valencia. This is crazy. And now they're at the point where, like, okay, y'all can go there. We won't hear you. Oh my gosh. He's almost at the end. It's 52 pages out of 56. So it's almost at the end.
Hold on. Judge Glanville handed a document to Kayla Bumpus, exited the chambers. Okay. Then the court says, okay, all right, Mr. Copeland, have you had an opportunity to speak with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? He said, no, Your Honor. Is it your desire to give testimony today? Yes, sir. So that's how it ended. And that's important as well. I wish we had a transcript of how it ended the first time before he got on the stand and pled the fifth, but we don't have that because it wasn't recorded, and we just have to take people's word for it. Copeland said he told him he was going to plead the fifth. The state attorney says he said he was going to testify. All right, and then they start to get into what size are you, and there's nothing else really that we need to get in with the transcript. But what I want to ask you is, overall, what are your thoughts now that we've heard the transcript? We've heard what the judge says, the judge's arguments. We know this hearing is coming. We'll see if another judge sees it the same way as Judge Glanville.
All right. Okay. Again, here's the balance. Glanville, he holds his hearing because the state requests it. Fine. The state can request a hearing. Then he should have asked the question, what is the emergency? Why do we have to do this ex parte? He really didn't do that. And we also know that after this hearing now, he's made a decision that it shouldn't have been ex parte. Otherwise, he wouldn't have turned over the transcripts because nobody else, no other judge is ordering him to turn the transcripts over. It's a decision he made. So he made a decision. There's nothing that happened at that hearing that the defense can't know, number one. Number two, he should have decided that during the course of the hearing when he discovered that there really wasn't an emergency. And therefore, he should have stopped the hearing and he should have allowed defense counsel to say, look, we're not going any farther until defense counsel is here at the hearing so they can be represented. He should have done that. His defense is going to be that this was a situation of retribution against the witness, so that's why it was an emergency, which there is case law that says you can't have an ex parte for that. That's his defense. But if you read the entirety of the transcript, it shows nobody was focusing on retribution. Nobody was focusing on him getting hurt because he testified. They were all trying to intimidate him into testifying and not take the fifth. It was all about that, nothing else. So the emergency nature was zero zilch, even though they're going to claim it. His sin was he did not do what a judge is supposed to do. The prosecutor was absolutely the worst. We learn all sorts of stuff about the way they conducted themselves, but it's up to the judge. He's supposed to be the neutral guy that sits there and calls balls and strikes and makes sure that the defendant gets a fair trial. He didn't do that. That's really the bottom line.
The only thing I can think of as we read this entire transcript is the defense attorney being there would have solved all the issues. There's no reason not. It's not like if anything, the state attorney accused this witness and his lawyer of conspiring with the defense attorneys and the defendants more than she accused them of potentially doing physical harm to this witness or potentially learning something that would be dangerous for this witness, which would be a reason to keep the defendant out if that was going to immediately put his life in danger. But instead she's saying, I don't know whose interest you guys are looking out for. And he's saying, I did these crimes. All I've been doing is lying. All that stuff is good for the defense.
Plus think how the atmosphere would have changed if when Steele got up there and said, there was this ex parte hearing and judge goes, you know what? You're right. I acknowledge that we have the ex parte hearing, Mr. Steele. You know what, Mr. Steele? I'm turning over the transcript to you here. This is going to be all done. Then read the transcript, and then you can come back and make whatever arguments you want. Just think how much different this would have turned out. But instead, he was, again, the cover up was worse than the crime. Again, he tried to cover this up. I mean, he really did. And I'm really surprised because he really shouldn't have. He just should have turned the transcript over.
Yeah, and that's the annoying part and the frustrating part. But I mean, this case is like never ending.
Okay, we'll stop it there. This was great. Agree it was preventable to continue it. Yeah, it seems, in my opinion. Valencia said, amen. Yes, we'll stop it there. They have a few minutes left, but I will try to get that link added as soon as I can. Please come to Instagram later on tonight because unless Jay gets busy or something happens on my end, we should be doing an unboxing. He's going to unbox one of my things from my store. So please come on over to Instagram. I should be up with him so you can join either of our lives. It opens up more questions about other witnesses. Yes, that's true. I saw that question earlier. It does open up more questions about other witnesses. Right. To have it laid out like that, this was good. This was good. But you have a good one too, Sweet Jane. I will see y'all a lot this weekend. Either more YSL. I got City Girl Mayor we got to catch up on. So yes, but I will see y'all. Thank you for hanging in there with me. We need to know what's going on, and I appreciate your company. And I will see y'all soon. Hopefully tonight on Instagram. Bye.
I've been taking my time, I've been taking my time. Taking all of your time, taking all of your time.